Welcome to our 21st Annual Ethics CLE Event. Thank you for attending. Hard to believe we've done this 21 years. There's one person in the room who was at the second, not the first, but the second. And we're going to do some recognition on the break. So we're going to have some prizes for the first time ever this year. So we're going to do who traveled the furthest and who attended the most. And there's a chance that could be the same person. I'm hoping no, but there's a chance it could be the same person. But we'll find out on the break. And then we have a raffle at the end. I'm trying to do social media, so I just beg your indulgence on this. So if you get your picture taken and put it on LinkedIn and talk to Taylor, you get in the raffle. And I can't remember, is the raffle the outrageously large knife?
It is.
Okay. We have this... We've got this great knife prize for whoever wants it at the end. All right, our first speakers are Clint Schumacher and Heather Moulder, both friends of mine. And this is the first year ever we've had two sets of two speakers at the same time. So I hope you guys enjoy this. I'm just going to kind of speak from the heart here. So I've known Clint for a very long time. He started out at Lock Lord, or what was it called then?
Back then it was Lock Cornell Rain.
Okay, and it is now
it's Troutman Pepper Lock.
Okay, he started out at Lock way back in the day. We got to know each other because one of my law school classmates worked with him, and so we've been friends for more than 20 years. And Heather is also a big firm lawyer. We've gotten to know each other for a long time as well. Clint is a eminent domain litigation focused, and then you also do commercial litigation. And Heather started off in big law, took a break, which I think she'll explain the story later, went back to big law, and now she's an executive coach for lawyers. And so they're going to speak to us. And what I love about this one is you guys are doing no slides whatsoever.
No.
All right, let's bring it on.
All right, so I'm super excited about the next 45 minutes, mostly because of Heather and what she's going to share. And it's going to be my job really just to kind of ask her questions and let us tap into her expertise. And I'm going to give her a proper introduction here in just a moment, but I think the best way for me to introduce it in a way that'll be meaningful for our next 45 minutes is to share just a small piece of story about me with you. In my law career, there have been 4 inflection points. The first came when I was a third-year lawyer, and I was in the parking lot of a movie theater in my car and broke down crying because it had become clear to me that I was failing all the important relationships in my life because of the amount of time and energy I was putting into being a young lawyer, and decided I needed to make some pivots. The next inflection point would have been about 10 or 11 years later when I was roughly a 15-year lawyer. And I slowed down enough while I was sitting in a park to finally think about the question of what do I want the next 15 years of my law practice to look like, and do I want to keep doing what it is that I'm doing? And decided to make some pivots at that point. And then another 3 or 4 years after that, as I thought about, okay, if this is what I'm going to be doing, am I doing it at the right place? I was at a law firm that I loved with people that I really, really enjoyed practicing with, but was struggling with the question about, is this the right fit for the practice that I want to have and the life that I want to have? And then the fourth inflection point, and this is where it gets to Heather, is now. Because I'm at the point where our youngest child is getting ready to go to college. My wife and I are going to be empty nesters. My primary mission outside the law practice has been coaching football at a small school. I decided to give that up after last fall. And so now all of a sudden there's all this time that I think I have, and I want to make sure I'm taking good care of it and I'm being worthy with it. And as I was going through that, I thought, I think I really need somebody to help me process this to make sure I'm taking advantage of this resource that I have all of a sudden. So I started doing research to find a coach, somebody that could help me walk through that. And I found Heather, who had a number of outstanding articles online that really resonated with the thought processes I was having. She has an excellent podcast, Life and Law podcast, or Life and Law. which is excellent. If you haven't found it yet, I very highly recommend it to you. It's available on, I found it on Spotify, but I think it's probably on all the places where you can get podcasts. And what I really appreciate about Heather is in our initial session, visiting, I found out that she asks really good questions. And then she stops talking and forces you to answer them. And she listens. And she's very insightful. And she has a very successful coaching practice now, I think, to lawyers and other professions. And so I'm really excited about the things that she's going to have to share, and maybe give you some thoughts that you haven't had, or give you some challenging things to consider like she has done for me. And so, Heather, kind of with that, I'll turn to you and let you tell your part of the story, and then we can go from there.
Okay. So I'm going to try to make this as short as I can. I had 2 inflection points in my career. The first was a couple of years in. I was the typical lawyer, at least young lawyer. I said yes to everybody. I did whatever was wanted of me. I had 0 boundaries, and I found myself really burning out a couple of years in. And there was this year where it was December. I was going home really late at night, watching the twinkling lights, listening to the most wonderful time of the year play on the radio, and I burst into tears because I could count on one hand the number of days that year I had not worked, including holidays and weekends. I was killing myself over, this job. And I was questioning, why did he even want this? And it was something I'd wanted to do since I was very young. I'm one of those strange people that knew I wanted to be a lawyer at the age of 11. So I go home, I walk in the door, I start complaining to my husband, and the poor man, who had been hearing this for a couple of years now, finally looked at me and said, Heather, you have a choice. Needless to say, that did not go over very well in the moment, but I woke up the next morning and I was finally ready to hear that. I was like, you know what? He's right, I do. So that was the first moment for me where I was like, I need to make better choices. I need to figure out how to make the practice work for me instead of just doing what everybody else wants. Eventually, that led me away from my first law firm and into a different firm. Funny enough, I went from a top regional firm at the time, Thompson & Knight. Many of you probably know Thompson & Knight. And then I moved to Greenberg Traurig, which is where I made partner, built my practice. And things actually went really well at GT. It was a very entrepreneurial firm at the time. Not sure it is anymore, but at the time it was, and I was able to build the practice I wanted my own way. Fast forward a number of years, and everything seems to be great. I have over $1 million practice. I'm doing really well. And then a phone call comes, and I find out I have very aggressive breast cancer. That, I did not know at the time, is the thing that ultimately changed the trajectory of what I did. I basically walked away that day not knowing if I'd ever be back. I was told to leave everything behind and go through a number of tests, etc. I was lucky enough to get into a trial that I think saved my life. And I think it was about 9.5, 10 months later, after a lot of chemo, several surgeries, I came back to the practice and slowly but surely built back up. I did that for several years, built a multi-million-dollar practice. There was something that didn't feel quite right, and I never could figure it out until this moment where I remember I'm washing dishes, and it was like I was looking at myself from above. I'm like, okay, that person looks like me. She sounds like me. She moves around like me, but this doesn't feel like me anymore, and I don't know what that means. So that set off a journey for me that took about 2.5 years to figure out, what do I actually want out of the rest of my life? And ultimately, I found that my breast cancer journey changed one of my core values, service. Still a big value, defined very differently. Service, pre-cancer Heather service was serve people to the best of my ability, show up as best I can. Now it's more about helping individuals live better lives. And initially, when I started this practice, I left 7 years ago, I thought I wanted to be a work-life balance coach. Over time, somehow but surely, more and more lawyers found me, found out I knew how to build business, and I primarily work with attorneys who want to scale or build their businesses I do some leadership coaching as well, and I do a little bit of what I call self-leadership coaching, which is the coaching that we do together. So that's my story and how I ended up here.
All right, so this is an ethics seminar, right? So we got to talk about ethics. So Texas Rule of Professional Conduct 1.15a provides that a lawyer shall decline a representation or withdraw from a representation if that lawyer's physical, mental, or psychological condition materially impairs the lawyer's fitness to represent the client. I don't think anybody, no secret here, we work in a profession that can at times be stressful, perhaps a lot of times be stressful. So really, Heather, question for you. While there's obviously wisdom in taking care of our physical and mental condition, how does that then bleed over into that being an ethical obligation?
So I think that lawyers have a misconception about clients always come first, and that leads us to not take very good care of ourselves. And it starts in small ways, but it bleeds into bigger things. I will say that the number of attorneys I've known to have ethics issues are not bad people, generally speaking, but they're people who have been under high levels of stress, probably chronic stress for a number of years, start to make very bad decisions, and it kind of spirals out of control. And I do think that ensuring you are well enough to do your job is an ethical obligation. And unfortunately, when you're in the middle of trial and you've got a bunch of other things going on and you go for weeks on end with 2 to 3 hours of sleep a night, I hate to break it to you, but you're not thinking as clearly as you think you are the next day. You're not doing your best, and decisions don't come very well. So there is that issue. We all also know that many lawyers we have this, it's the nature of the beast attitude about what it is to practice law, which then convinces us to just put up with the stress and not learn how to manage it appropriately. And when we do that, we're in a near constant state of fight or flight. We all know what fight or flight is, right? Well, chronic stress is basically almost always in that state, which means there's a bunch of chemicals being released in your body, which is degrading you physically, but also degrading you mentally, because you don't think as rationally, you are not thinking as creatively. And something I never thought of for a long time as a lawyer was creativity is key to being a good lawyer. I didn't think of myself as a creative, but the fact is we do need to be creative to problem solve the way we need to. And all of that gets shut down when your body is flooded with those chemicals. You just can't think very clearly. So I think very strongly that it is an ethical obligation to take care of ourselves appropriately, and that includes learning how to manage stress better. Not just get rid of it, but manage it from a long-term perspective, because you can't get rid of all stress.
Okay, so let's build on that for a minute. So probably any number of us worked in practices that are stressful. Things pop up, adversities arise, the unexpected happens, obstacles arise. So just talking about mindset for a minute. I mean, is there a framework that you teach in dealing with adverse events when they pop up, even unexpectedly?
You're getting an E plus R equals O, right?
That's one of my favorites, yes.
Yeah. So has anybody ever heard E plus R equals O, event plus response equals outcome? So think about it this way. You have an event, it's happened. Regardless of whether you contributed to that event happening, what's happened has happened, right? Then there's a response. Those two things go together, they create the outcome. What is it that most lawyers actually focus on? Yes. Do we have control over the outcome? No. So I always tell my clients that 80% or more of your stress is mostly you, not the event. It's the way you're perceiving the event, the way you're reacting to the event, and then the fact that you're obsessing over an outcome that you cannot control. That creates a lot more stress. So is there stress? Yes, we're always going to have stress. But we lawyers create a lot more stress by not focusing on the right thing. So when you learn to focus on the right thing, the R piece, that's when you can take more control and actually then reduce your stress levels, because you're not obsessing over stuff you can't control and freaking out over it. But then you can actually do a better job of reducing your stress, managing your stress. So that's the framework that we're talking about.
Okay. I like that. We would teach that to our athletes. I thought that was strictly an athletic thing, but then I saw it in Heather's materials. I'm like, okay, that's got a broader application. So that's cool.
Yes.
Okay, so I read a lot online about a concept called mindfulness. Do you mind maybe kind of talking about what is mindfulness, and perhaps for people in this room, can a lawyer who is short on time still employ this concept of mindfulness?
Yes.
Okay.
So who here thinks of mindfulness as primarily meditation? Okay, a couple people. Who here actually has tried meditation? Anybody who's tried meditation, given up on it because it's too time consuming or it doesn't work for you because, okay. So for those that it doesn't work for, is it because your mind is constantly spinning? It's working. It can still work, I promise. I'll explain that later. But so mindfulness to me, I think, first off, that coaching and a lot of people who talk about it do a real disservice because they don't talk about it very well. We talk about it as tools, which they are, to reduce stress, which they are. They can be utilized in that way, but there's a lot more to mindfulness than that. And there's a bigger purpose and point. So get back to the E plus R equals O. You want to focus on the response portion. Most of the response is actually not the outward response. It's the internal response. It's the thinking. It's what your beliefs are. It's what you choose because of those beliefs that then cause you to have an outward response. So the best indication that I can give you, let's say you are working on a project for a client that's really difficult and is requiring a lot of late nights, late hours. You think it's due in 10 days. They call you and say, I'm sorry, I need it in 4. Well, you have a choice in that moment. You can choose to step back, utilize some tools to calm down, because you're going to go in fight or flight in that moment, most likely. And then utilize mindfulness to figure out, what am I thinking, what's going on, so you can kind of break it down and unpack it. Or you can immediately react. Now, regardless of what you do or don't do, the deadline is not going to change. It's still going to suck. You're still going to have to put in a lot of time. That portion of the stress won't change. But you could call in your entire team, ream them out, because you know what rolls downhill, right? Take it out on them, cause a whole host of stress on them. They won't do as good of a job. Call your spouse, tell them you won't be making anything, complain to everybody who will ever listen to you, and get the job done. Or you can take a couple of minutes to unpack it, reframe, and we can get into what reframing is in a minute. And the sucky part's still going to suck, but you've calmed down. You realize, you know what, I need some things I got to give away. This I can renegotiate with a client. This is going to be a chance for me to really step up and show my leadership. I'm going to help my team with this. There are ways to view it, that's what reframing is, that helps you get through it better. So mindfulness is really about utilizing these tools so that, number one, you can become more self-aware of the thinking, the thoughts, the things that you believe that make you act the way you do. That gives you more choices. Oftentimes we have thoughts we don't even realize we have because of something that happened 10 years ago. And our brain says, it's always going to happen that way. We don't consciously know we're doing that. So this allows you to become more conscious of some of the thinking you've got going on, which then gives you an opportunity to review it, ask yourself, does this always apply? And then choose what you want to believe moving forward. That's number one. That's one of the biggest things about mindfulness that I think people don't understand. The benefit of that over time is you can really change how you think. And when you change how you think, you change how you react. So that's number one. The second part is it enables you to step back, calm down, get rid of some of that stress response so you can think more rationally, so that you can problem solve better, which we all need in those situations. And then it also enables you to move forward, understanding that, yes, this still sucks, but I'm reducing some of this stress because I'm not going to react. I'm responding appropriately. So you reduce some of the stress in the first place. So that's a lot of what mindfulness is really about. It's not just about utilizing the tool in the moment. It's about understanding the tools that are available so that you can use them in daily life and when you need them. And this whole time-consuming thing, I think most people incorrectly think of meditation as the main mindfulness. And meditation is wonderful, and there's all kinds of things you can do with it. But I have found that most lawyers are not big on meditating for lengthy periods of time, and that's totally okay. You could do a 3-minute meditation if you want. And by the way, you don't have to meditate. Like, I have clients who do meditate and love it, but they do it short bursts, 1 to 3 minutes, 5 minutes max, whenever they need it. The one thing I would say is utilizing these tools saves time because it puts you in a better position. It makes you more efficient. It makes you more productive.
Okay, so I have a disconnect around that. I'm off script here. For a minute. All right, so you get the call that kind of sets off the chain of events, and you're saying, okay, you want to reframe that, deal with that in a more productive way than perhaps you've done in the past. So, but it strikes me that in that moment, I'm not all of a sudden going to be able to deal with it better if I haven't done the work ahead of time to get there. So what does that look like? And I've never completely understood why meditation then feeds into my ability to deal with that stressful moment when it arises.
So meditation does a couple of things, and I'm going to answer, there's a couple questions there. So when it comes to meditation, if you do it regularly, you train your brain to focus in better. So for all of you who think you're doing it wrong every time you notice you're like wandering, the way meditation works, and it's supposed to work this way, is your mind's going to wander. That's normal. And it is especially normal when you're really busy and not giving your brain space. We need space for those thoughts to come forward. I often tell my clients when they first start meditating, have a journal with you because thoughts are going to come to you that are going to seem important. You might want to write those down. That's okay and it's normal. The thing is you want to notice the thoughts and then you want to take your brain back to your focal point. Usually it's like you're breathing or something you're looking at, something you're paying attention to. Every time you notice that your brain has wandered and you bring it back, you're actually creating new wiring in your brain to learn how to become more focused and also to notice when you're not. So that's one of the other benefits of meditation specifically. When it comes to, you're right, you're not going to say one day, oh, I'm just going to start using this. I love this presentation. I love reframing. All this stuff sounds great. Well, you're not going to just start doing it, right, immediately. Well, so you have to build a practice around it. And that's where the practice comes in. It's also where coaching comes in for a lot of people because a coach can help you, A, identify when to use these tools, B, identify how to become more self-aware when you want to use these tools, and C, help hold you accountable for utilizing them. When you know you're going to meet with somebody regularly and talk about it, you're a lot more likely to go, oh, I'm in that situation where I said I'd use it. I'll use it now and see how it works. So it's a practice. You want to utilize them. I think a lot of people think that they just utilize them in the moments of stress. No, you want to utilize it daily. So a great way to get started is maybe end of the day, practice some reframing. You can look back. And that's how most of my clients start. It's like every day for 5 minutes at the end of the day, they review their day and they find things they can reframe. Okay, well, that part sucked, but here's the good part in it. It trains you to start thinking about it. And then over time, you start to notice it in the moment and you start utilizing it. And then it becomes second nature.
Okay. We jumped into something specific right off the bat, which is great. But let me take a step up or a step back for a minute, and go to a higher level. So as you talk to lawyers reach out to you, what kind of themes, what kind of issues are common, and how can a coach or whatever the right resource is feed into that?
So I think some of this has to do with the kind of coaching I do. Since I'm mostly a business and leadership coach, the one thing I hear the most is I have no time. I have no time. I want to do all these things, but I have no time. And there's a lot to unpack with the I have no time, but the one thing I've found to be the most common with us lawyers is somehow we've convinced ourselves we shouldn't have to make trade-offs. And it's not true. There's a trade-off with every decision you make. And we don't like that. So a lot of us goes into the mindset piece that we don't like hearing that. We don't want to have to make decisions that involve trade-offs. And so we try to do everything. And I will say, that do it all that most women have fallen prey to is a big part of this, but that's not just a female thing. Most men do the same thing. They just use different language around it. Okay? That I've definitively found. I think a lot of people falsely think it's women only who feel and think this way, and that is not true in my experience with my clients and the lawyers I've known. And so there's a lot of mindset stuff going on with the time. And at the end of the day, there's only so much time in the day. There's only so many things that can be fit in. You have to learn how to prioritize and really understand, what are my priorities? What do I really want to get done with the time that I have? And laser focus on those, and then cut everything else out. And that's where boundaries come into play. The other thing I see coming up all the time is lawyers are people pleasers. Like, we don't like saying no to people. We want to be able to help and do for others. And we feel really, really bad when we say no. And it's really important to understand that when you say yes to something, you are also saying no to something. So get really honest about that and understand there, again, is a trade-off, so that you can make the right choice as to what to say yes and no to.
All right, let's talk about motivation. What advice do you have for the lawyer who goes, you know what, I'm not feeling it. I'm not as motivated as I used to be. I'm concerned that my love for my practice is waning. You got anything that's worth sharing?
Yes.
Okay.
So that could mean a couple different things. Sometimes it means you're burning out. Sometimes it means you need to step back. It's pretty common to feel very unmotivated when you are in burnout. And so that's something to pay a lot of attention to. And understand also that burnout does not only happen because you work a lot. It happens for a variety of reasons. And for a lot of lawyers, we think it's just the hours. That is a piece of the puzzle. But if you have a bunch of clients that you really just don't like, and you're not really into what that client and helping them do that thing, that can create burnout. It can really cause, and a lot of people go into the law for reasons, like purposeful reasons. They want to help, they want to do good, and they end up in a practice because they just kind of follow the rules and do the thing everybody else says to do. They end up creating a practice they don't much like. It may not be the law, it may be the industry you're in. It may be the particular clients you serve, or it may be a couple of clients that are really pulling at you. Also could be your law firm. And I am not one, there are toxic law firms out there, don't get me wrong, but a lot of law firms aren't as toxic in and of themselves as people think, but they could be toxic for you because they're not a good fit for you and your personality, your values. So those are a couple of things that I would say you want to really pay attention to when it comes to burnout. And then the other piece is, it might be time to move on. There are a lot of lawyers who come to me saying, I've done this forever, I loved it, but I just don't think I love this anymore and I want to do something else. But we lawyers are scared to death to even contemplate that. I went to law school, I spent all this money, I have all this time and energy involved. People would think I'm crazy. By the way, that's usually the biggest issue and you don't even know it. What will other people think if I left the practice? And I have to say, I did that. I knew very clearly I was not meant to practice anymore. And it bothered me that people would look at me differently, not respect me the same. I'm here to tell you, people actually don't think that much about you. They're thinking about them. We all worry so much about what other people are thinking about us, and they're not even thinking about you. But that's one of the big things that stops a lot of people. I would say, take some time to get back to your values, know what they are, know what they mean to you now in this phase of life. It is not uncommon in different phases of life to reframe your values, to have a little bit of a different take, and for that to lead you somewhere new. And it might not mean a completely different, you leave the law, but it might mean a different law firm or a different way of practicing or a different kind of client. It could be a lot of things.
Okay, can we dig into that a little bit? So if you're going through the thought process of, gosh, I don't know if this is what I'm supposed to be doing, whether it's at a professional level or a industry level or a practice area level, and you said, okay, reconsider what your values are, what you want to be about. Practically, what does that look like? I mean, how do you do that? What's the process for that?
Well, usually people work with a coach for this, unless it comes intuitively. For some of you, it comes very intuitively. For me, values were always big, and I kind of just understood what they were. For some of us, we don't think about it a whole lot, so it kind of depends. I hate to break that. I hate saying that usually, but it does. I would say this, though. Get back to, okay, what's most important to me? Who do I want people to think I am? What and why is that important to me? And is that about ego, or is that about other people will respect me more, or is that about, no, that makes me a good person and that's who I want people to, that's who I want to be. That's what I want them saying about me. I will say this, when I was diagnosed, the day I found out, I sat there and I thought back to my grandfather's funeral. And he was an incredibly successful man who had done a lot in the world, but his funeral was standing room only. Thousands of people showed up. It shocked us. And the number of people that came up to us and said he had a direct impact on their lives in the way that he, did things for them, how he showed up when he was with them, made a big impact on me. I sat there and said, well, if I die, I'm not going to have that many people at my funeral. And I don't think they're going to say the same things about me. They're not going to say anything mean, but I have not made that impact on them. And that's a value showing up. That's something that's core to who I am and how I want to be in this life. That stuck with me. That's the reason why a number of years later, I was like, something's off. And I had to figure out, well, what does that mean? So we all have that. And you may call it principles. It doesn't matter what you call it. There are things that are really important to who you are, how you show up in your day-to-day life. That's what you want to get to, is what words do I put to that? And not just words, how do I define that? What does that mean to me? And then you can identify, okay, well, how am I doing that in my day-to-day now? And what are some small steps to fill the gap if I'm not? When I work with people, that's what we do. We identify, define, and then we start to fill the gaps. And I will say that a lot of times people assume it means like jumping off the cliff and leaving law practice and starting a coaching practice like I did. Most of the time, that's not what it is. It's not that big of a change. It might be, but it very well might not be. So don't let fear of what could happen stop you from looking.
Okay, so everything you said reminded me of two quick stories that are worth sharing. One is I have just read a book called The 5 Types of Wealth by Sahil Bloom, which was excellent. And he asked a very penetrating question, which is, who are the people that are going to be sitting in the front row of your funeral? And how is your relationship with all those people? And I was like, whoa, that's a deep question, but a good question. And then on this question about principles, I call them core values. I'll share that Darren and I had breakfast some number of years ago, and he had just been through the process of determining what his own core values were. And then he asked me a very embarrassing question, which was what mine were. I said, no idea. I don't know. Couldn't tell you. Work at a law firm that's got core values on the wall. I coach a youth football team that's got core values, but I don't know what my own are. And it kind of started a multi-week journey of trying to figure that out. And I'm so thankful he asked me that question, because what I found was it makes every other decision in life easier. Once I decided, hey, these are the 5 things that matter to me and who I want to be, then everything else can fall in line behind that. And so just if you haven't done that, give that some thought. Okay, so Heather, younger me would have said, I don't need a resource, a coach, or anything else to help me be a good lawyer, to help me be the best me I can be, to help me figure out what it is that I want to do in this world and how I want to show up. What do you say to those people?
You're afraid, younger you was afraid to admit you needed help. Right?
Totally, 100%.
Yeah. That's pretty common amongst us lawyers. So I will share a story. I'm the oldest of 5. I'm the only lawyer. I am the person in my family everyone always came to for advice, to help them with anything. Getting cancer was the hardest thing I've ever been through, not because of the cancer itself, but because I was vulnerable and I had to get help from other people, and I hated every second of that. So it was really a tough process for me for a number of months, to the point where I fainted one day in the bathroom, and I crumpled right down, like I've hit the wall, crumpled down. My husband heard me, and he's like banging on the door trying to figure out what's wrong with you, and I'm lying, it's fine, nothing, so I get it. But here is what I learned. We humans are vulnerable people. It is a fact of life. We might as well accept it, because when we accept it and we open ourselves to getting help when we do need it, I believe very strongly that every human being has strengths, and we are meant to utilize our strengths. They are a gift from God, and we are supposed to use them for the benefit of others. That means that, yes, you're supposed to use your strengths for people, but other people are supposed to use theirs for your benefit too. And if you don't allow them to do that, you are depriving them of something really important, but you're also depriving yourself of a real deep connection. Because when you open yourself up to that type of vulnerability and accept the help that's being offered, there is a connection that happens that shocked me that is very powerful. The other thing is you start to learn there's actually strength in vulnerability because it builds resilience, and it shows a strength of character when you admit that, yeah, I don't know everything. I could use help here.
Okay, so we're running close on time, and we wanted to absolutely leave some time for any questions that you guys have, particularly of Heather. So questions, thoughts, comments?
Rarely ask.
Do what?
They usually don't ask a lot. Any specific questions about, like, how to use a tool or something easy? If you do have questions, please feel free to reach out. You can find me on LinkedIn. You can DM me there. It's Moulder, Moulder. And if anybody's interested in any of the resources that I have, feel free to reach out too, and I'm happy to get them to you. We talked about values. I have a values assessment I'm happy to give you. I also have a toolkit that has a lot of the mindfulness type stuff we talked about if you want it. So feel free to just reach out and I'll send them to you.
Perfect. Thank you very much. We appreciate it.
Okay, so as you guys know, Care Load is our firm charity. It is Memorial Day weekend. If you guys are interested, there's a QR code. Essentially, the goal of Care Load is to put Memorial back into Memorial Day weekend. It raises millions of dollars for first responders and veterans, the families of those who gave all. I'll be out there this year, as I have the last couple of years. I'm carrying a guy named Mark Crampton. We called him Cramps. He was about a 30-year Navy SEAL. He was a mentor of mine. We lost him about 3 years ago. Great guy. So it's Sunday, Memorial Day weekend, and it's a 20-hour ruck. Not seeing any hands in the air for that in the group, but it goes from 4 o'clock on Sunday till noon on Monday. But there's lots of ways you can get involved. The opening ceremony enough is worth it. We have between 5,000 and 10,000 people show up at Reverchon Park over the weekend. So if you guys are interested or want to join our team, there's the QR code. And something exciting, particularly for the in-house legal department, we have partnered up with the Admin Awards this year. And the Admin Awards, I'm not going to read the slide, but the Admin Awards basically honors basically admins and EAs, usually from larger companies. And so they put on a gala every November, and it's kind of a big deal. So you can nominations will open up, I believe, in May, but we'll make a big deal about it in August. The event's in November. So EAs are essentially nominated, and they go into like an Oprah-style, rock star, raucous event where they just get showered with love. And so if anybody has a great EA, stay tuned. We'll get an email out to you guys in a couple months. And there's talk that there may be an award for legal department EAs. If there are, I'll make sure to get that out to you guys. Even if they don't make it, the nomination itself will earn you creds with your EA. And if you make it, we have a table and we'd be happy to host you. And it is a love fest for EAs. Okay, first prize winner. So this is a tough one because we've got traveled the furthest and most years attended. And I'm worried one guy's going to win both. Let's go most years attended. So if you've been 4 years or more, let's get you a stand up. 4 years or more. 4 years, okay. Wow, okay, we got more than I thought. All right, 6 years or more. Keep standing. All right, if you're at the firm, you don't count because you're here by, you have to be here. All right, 6 years or more, we got 3 of you guys. All right, 8 years or more. 10 years or more. You're like 16 years. What is it, 15? All right, Russ wins. All right, and then the next one is traveled the furthest. Russ came all the way today from San Antonio. So I'm hoping somebody beats him, but I don't know. So if you were further than San Antonio to get to this event, raise your hand or stand up. Yeah, that's what I thought. Okay, all right. 20 miles or further. And not from the firm. All right, we got 3. Okay, how about 30 miles or further? Woo, all right, 50. All right, where are you guys? I'm not going to keep guessing. Where are you guys from? The Woodlands? Oh, that's far. Oh, Houston wins. Okay. Very nice. All right, our next 2 presenters are 2 wonderful mediators in town, John Shipp and John DeGroote, and I don't think they really need much of an introduction.
I'm John Shipp.
I'm John DeGroote. Good to see everybody. I know a lot of the folks out here. See some friendly faces. Thank y'all for being here.
So when Darren first asked me to give this presentation, and by the way, you're going to have to bear with us. This is the second speech that John and I have given today. We've already given a speech on 10 things that your mediator won't tell you.
That's right.
Yeah. And so now we're here talking about ethics and negotiation. And I will tell you that if you ask me to give a speech just about mediation and I can get up in front of somebody and just fake it until you make it. We didn't on the 10 things, but I can do that backwards and forwards without an issue. When you start talking about ethics and negotiation, this is probably one of the more difficult speeches that I've had to put together and prepare, because things are not near as black and white and clear as maybe I thought they were before I actually sat down and started thinking about it. And so this is a really interesting topic. And over the course of this speech, we're going to talk about maybe some hypotheticals, and we may throw some of these out to you all, and we'd love to hear your thoughts on it. About and you'll hear about whether something is ethical. You'll hear about whether something is moral, and those are 2 separate things, by the way. And so whether something is ethical and whether something's moral, or whether they're both or neither. And so John is going to talk a little bit about negotiation ethics and why this is so difficult.
You got it. We'll dive right in. I will say 2 things, though. First and foremost is I still have a trial lawyer's attention span. So love getting questions. Feel free to say squirrel, and I'll look, I promise. And let's and truly, as questions come up, the most important question today is, how can we help y'all with this? That's 1. And then 2 is, when I was getting ready for this talk and John and I were putting things together, I remembered a buddy of mine in law school who aced the ethics part of the bar exam. And let's just say he was the last person that I would have thought would have aced it. And I said something to him, and he said, "Oh, I plan to know those rules better than anybody else." And so I took some comfort in the idea that I didn't know him quite as well as I might have wanted to. But that with all that said, hey Taylor, if you can go to the next slide, there we go. And so the whole idea, negotiation ethics or legal ethics, some people say, is it an oxymoron? And I had a little fun today, because I looked on Claude. Most people are on Chat GPT, and looked up good oxymorons. Of course, everybody's heard jumbo shrimp, but my new favorite is deafening silence. But the question is negotiation ethics really an oxymoron? And I think it's not, and I think it's something that helps us all to know a little bit about. But the reason it's so difficult is because we have multiple layers of constructs here. And we're going to talk a little bit about morals and ethics and the ethical rules and how all of those interplay. But the important piece is that a whole lot of this is personal to each one of us, and at the same time, we're all bound to the same rules. And the question is, how do those 2 concepts interplay? And at the end of the day, the question is, do we have guidelines that may guide us, and where are the bright line objective standards, if anywhere?
Well, I think yes, in the societal. Yeah, go ahead, Taylor. That's fine. You can move to the next one. I think the first place to start is we just talk about societal conventions, just generally in society. I will tell you, coming here, like John, I see a lot of people that I know, and some people I haven't seen in a while. Russ Holloway right here. I used to play poker with Russ,
Uh-oh.
And if you think about poker, for example, I mean, the entire idea of poker is to misrepresent what your hand is. And by the way, his favorite hand is a 2-7, if you can believe that. Offsuit 2-7, yes. And so that is considered to be something that's okay. But what are some other examples of things, societal conventions where we think to ourselves, we know it's not necessarily the truth, but we just go ahead and accept it as something being okay. One of the examples is the Papa John's example. And John, I don't know if you wanted to.
Yeah, I'll run with that. Anybody here from either Pizza Hut or Papa John's? There we go. So it is hopefully I don't make any enemies here, but the case is the case. Back in 1998, Pizza Hut sued Papa John's and said that their slogan, better ingredients, better pizza, was false and misleading, and all manner of claims that rolled off of that. And the federal judge agreed back in 2000 and said that that's an improper slogan, or it's a misrepresentation of fact. And the Fifth Circuit reversed and said that's an opinion. And I'm sure there are lots of nuances, but that's the net impact 20 years later as I look back, or 25 years later. And the idea there really is, when we hear something like better ingredients, better pizza, do we think of that as a representation of fact, or is it just advertising? And so that's just one of them. But John's got other examples as well.
We all grown up, especially the men in the room here, Gillette, the best a man can get. Overpriced razors are the best we can get. And do we really believe that? How do they know that? Duracell lasts even longer than what? A potato battery, who knows? We don't know. Some of the, an example is sometimes when you see these pictures of the cereal and it looks very appetizing with the milk and it's creamy and it's white, it's actually glue. That's what they use. One of the ones that, and this is a real world example that I want you to all to think about when you go to the grocery store, is when you're buying salmon. We all think of salmon as being that pretty orange color. The reality is that salmon is the salmon that is wild caught, and shrimp and krill is what gives it that pretty orange color. Farm-raised salmon are gray, and what the grocery stores do is they actually color it. We consider this to be okay in the context of just what we do in society, but that, to me, you would argue is misrepresentation. Don't eat gray salmon. Don't eat food-colored salmon. I think RFK just outlawed the dyes. So you can't. We don't have to worry about that anymore anyway. But some of the more recent ones that I can think about, and this is not to bag on our brethren Thomas J. Henry, but it is beat into my head. The firm the name the firm you trust, and I think to myself, well, I do trust them. I don't know why I trust them, but I've heard it so many times now. How do they know I trust them? Is Thomas J. Henry gone out and actually figured out, that whether we really do trust him or should trust him? And I certainly know who he is because the advertisements are over. He has a private jet. We must trust him. But those are the kind of things. The other one that's kind of clever that has come out recently is it was a Super Bowl commercial. It was Homes.com, and it's got Morgan Freeman in it, and it's got Heidi Gardner from Saturday Night Live, and Dan Levy, who's in Schitt's Creek, that TV show. And they have the Academy Award should go to the guy that no one knows who he is, who's the put upon in-house lawyer who's telling them that they can't say that Homes.com is the best. And they say, well, what if we say it in Spanish? What if we whisper it? What if we do this? And what if Morgan Freeman says it? And and they just keep repeating it over and over again that Homes.com is the best. And so obviously the idea being is they can't represent this best, but the whole idea of the commercial is obviously trying to get around that. But those are all just kind of examples of things in society we just kind of accept that or consider to be acceptable. So, John, let me ask you this: how do we, when we talk about, I brought up the difference. There's a difference between ethics and morals, but I think we need to go in and talk a little bit about what ethics are.
So what we'll do is I'm not going to read very much from slides, but there are two slides I want to read, and then we're going to kind of tease out the difference. But ethics are moral principles that govern a person's behavior or the conducting of the activity. Whereas, and Taylor, we can go to the next one as well. Whereas morals are principles governing right and wrong, or good and bad behavior. And the important piece there, because those sound a whole lot alike, and in fact, when I read those two together, they just seem to kind of blend together. And then we get to what the real differences are. And importantly, I think these differences are going to have an impact on us as we get to the rules that we all are compelled to follow.
So when I was getting ready for this and putting this together, I really had not made much of a distinction between ethics and morals. I just kind of had conflated the two and kind of thought they were the same thing. And we all have our own kind of moral code. But as John said, ethics are a set of rules, and they may not be moral rules. Ethical rules that would govern everybody in here today, which we're all getting CLE credit here, is the disciplinary rules. Those are a external set of rules that we live by about what is considered to be ethical and what is considered not to be ethical. The interesting thing is you can have ethical rules that may not be moral. The mafia, for example, the Omerta code. You never rat on somebody else. Somebody murders somebody. That's immoral, where we would argue that it's immoral, but it would be a violation of ethics for somebody in the mob to rat somebody out that they saw somebody kill somebody. That's an example of that. Likewise, you can have conduct that's can be moral but not ethical. I've seen this none of us would do this, but I've seen this in a movie where a lawyer was representing a client who had killed somebody and murdered somebody, and he was a serial killer. I think it was a Kevin Bacon, Gary Oldman movie or something, and killed somebody, and basically he came out and said he did it. He killed the guy. That would be unethical under the disciplinary rules, but it may be the moral thing to do from the standpoint of what's right and what's wrong. And so this all gets more and more confusing. Some things can be ethical, some things can be ethical and immoral, some things can be vice versa. John, what do you have anything?
Well, one of the things, and when John and I were getting ready for this, it occurred to me that really you just have two different strata or two different filters you need to filter through: the ethical standards, which apply to the society as a group or subsets of society, whether it's lawyers or there's an advertising code, or I bet investment bankers have one too, but we're not going to go there. And but at the same time, you look at those two different sets of standards, and for me, just the way that my shortcut for me is when I see immoral or moral, I just say to me, because I can't tell Ken Kula it is immoral to Ken for Fred to do X or Y or Z or whatever else. And so understanding there are two filters there, I think is a great start. And so Taylor, if we go on to the next slide, for us the question is what are the ethical rules that apply here, and particularly focusing on negotiation and ethics in negotiation. And we have the Texas Rules of Disciplinary Conduct, and there's a preamble, and we have Rule 4.01A and B that I think we're going to focus on most today. And Taylor, if you want to get us to that, the preamble, and I'm going to use like Austin Powers, I'm going to have a little bit of emphasis here, but as a negotiator, a lawyer seeks a result advantageous to the client, but consistent with the requirements of honest dealing with others. And so you really have a tension there between doing the best you can with your client, but obviously there are standards you have to adhere to. And once you get into the rule, and I won't read the entire rule, but basically in connection with representing a client, a lawyer shall not knowingly make a false statement of material fact or law, or fail to disclose a material fact to a third person when disclosure is necessary to avoid making, in effect, a crime or a fraudulent statement and a fraudulent act perpetrated by the client.
So in other words, tell the truth.
It is. If you're speaking, tell the truth, and if your client is making a representation or otherwise engaging in criminal or fraudulent activity, you have to speak up and tell the truth. You can't just stay silent.
All right. So we're done, right? That's the end of the
Yeah,
speech.
yeah, that's it. We can all sit there. Just tell the truth and we're done.
Tell the truth.
Right, and exactly. So that's exactly it. And then we move on to the next slide, because we now have once we get into the comments, we see that the fine print does taketh away, just like in contracts, and we see though that there are exceptions to this. And by the way, this goes back to where we started, and that is Gillette, the best a man can get, or better ingredients, better pizza. There are some things that are said in negotiation that are not thought to be material representations of fact, or they are otherwise accepted. And for example, in a negotiation, an estimate of a price or a value is not thought of to be a material representation of fact, or intentions as to an acceptable settlement. The exact same thing. And so if you know, the way that I read this anyway, if you know that your client is willing to pay $100,000 and you say, look, you know what, I don't think you're going to get 40 grand out of my client today. Does that violate the rules? According to the rules here in the comment where it says intentions to an acceptable settlement or exceptions to the rule, you're in according to the rule here, you're in a safe harbor. And now, by the way, again, remember 2 filters. Is that moral to me? Is that moral to Ken? I don't know, but ethically, does it pass muster under the rules? It does. And so, John, how does that sometimes play out in mediation?
Well, there's not a whole lot of guidance as to what would be an ethical breach in mediation. And by the way, just in the context of mediation, there's maybe more incentive to maybe bend the truth a little bit, because as you know, everything is confidential in mediation. And if Vegas is what stays in Vegas, what happens in Vegas stays in Vegas. Mediation, everything is confidential, nothing could be shared. Mediation is kind of Vegas for liars, or it could be. And so, from the standpoint of where do we look to try and get some guidance, the ABA, there's a formal opinion 06439, which is applying Rule 4.1, the ABA Model 4.1, which is the basis for 4.01 that John just talked about. It says we can't make false statements of material fact, but it does say that posturing, puffing, and negotiation is acceptable. You can be less than forthcoming as long as no material facts are misrepresented. During this, you might exaggerate or emphasize the strengths, or minimize or de-emphasize the weaknesses of factual positions. These are considered to be acceptable type things. You can downplay the willingness to compromise. You can fail to disclose your bottom line. You can overstate or understate the strength or weakness of a claim. These are all back to the societal conventions and back to what was considered to be ethical. And as John keeps repeating, the end part of what's moral to me, because everybody has their kind of own moral set about what's or moral values. And so, let's say, for example, that you've got lawyers in a negotiation, and one represents that a witness is going to say that they're going to say that the witness is going to say that it was a car wreck. Witness is going to say that they represent the witness is going to say that they saw the car wreck and it was the defendant's fault. Do we think, and let's assume that the witness is not going to say that, or he doesn't know he's going to say that. Do we think that's ethical? Russ is shaking his head no. Anybody else think it's ethical? Yeah, it's not true. Another example is let's say in a labor negotiations, a attorney says, well, we can't do this deal because it's going to cost our client $100 an employee when he really knows it's $20 an employee. Can you do that? Anybody? I would say if he knows for a fact that it will only cost $20, that's unethical. What if he just thinks that? What if he thinks that, but he thinks it's $100, but he hasn't really done a whole lot of research on that? How he phrases it. Okay.
All of that assumes, though, that it's material to the negotiations.
Yes.
And because if it's not a material fact and there's a misrepresentation, again, it may be immoral to Ken and to me, but not it may not be unethical if it's immaterial.
What about this is an interesting one on, let's say that an attorney is represented that there is coverage, insurance coverage to the plaintiff of $200,000 when there's really a $1 million policy. Terrifying. What if the attorney doesn't?
Can I push back on that just slightly? What if the plaintiff's maximum claim is 25 grand? I'm just trying to tease it out where it's no longer a material fact. Now, of course, I don't want to be the guy whose only salvation is that my lie was immaterial, but I do. But I do want to at least pull it back to the rules, for that. But I'm generally with you unless we can figure out it's immaterial.
Okay, so if it's may not be, but everybody agree that maybe that's not moral, right? Okay. But if you're right, if the maximum amount of claim is $25,000, it very well may be that it's not unethical because it's not a breach of a material fact.
Right. Yes, and some might say the fact that it was being represented implies it's material, but that's a whole nother rabbit trail for sure. And by the way, just let me throw one out there.
Yeah.
And that is, and John and I talk about this a lot, but there are a lot of nuances that are lost on me. But in the negotiation process, words like can't, don't, want to, authority, things like that are words that I never forget. And so when somebody says to me, my client doesn't want to pay $1 million, is that different than my client doesn't have authority past $1 million? Those are two very different things. And by the way, my client doesn't want to pay $1 million might be an opinion, and it might be better ingredients, better pizza. And but it certainly would fall under the exception, or to me, it would certainly fall under the exception of expectations of a client's willingness to settle. But once you get into the material fact of the bounds of authority, then all of a sudden you're into a different realm. And by the way, just to tease that out a little bit, and I have actually seen this before. What if the defense lawyer knows that she can get $1 million to settle the case, but asks the carrier, please only give me $200,000 in authority, and goes to the mediation and says, my authority is up to $200,000. Is that a misrepresentation of material fact? It is not. And so technically it would seem like she would be safe under the ethical rules. But is that moral to you? I would hope not. But yeah.
Question about the materiality. Does it have to be material to the negotiating making or to the underlying facts of the case? Like, I think about this. A lot of times you're going to have a negotiated settlement where there's going to be a statement in the settlement agreement that there's denial of liability, right? So you're negotiating over the settlement amount rather
I think the form, John and I have a very similar form, and that's not by accident. And but I think the way that our form treats that is, rather than making a representation as to liability, it says both parties deny liability, and the settlement's not an acknowledgement of liability. And just by denying it doesn't mean that it, as we know, doesn't mean that that it didn't happen, and now we're settling it, and it therefore goes on by the wayside. But you raise a point that I think is really important, because we talked about in mediation, if the mediation is confidential, and so what everybody said at mediation, you know, the light was green, and that was the premise of the settlement. And the settlement check gets cut, and all of a sudden it comes out that the light was red, and I get a subpoena to go by, in an effort to bust the settlement. What happens when I get that subpoena, John, to go testify as to what happened in the mediation?
You're calling the other attorney up and invoking your indemnity clause.
Step one and step two is the mediation confidentiality, at least in Texas, Chapter 154 will likely preclude my testimony on that issue, which is why, and then I come, which is why our form settlement agreements, which do differ slightly, but they say, to the extent there is a fact that is critical to this settlement, it is embodied within the settlement agreement, and that way we don't have to go there. But that's an excellent question. It was the mediation confidentiality, to my understanding, at least whether I can be called or not, does not hinge on whether a fraud was perpetrated there or not. The confidentiality holds, and as to my understanding, whether there are collateral fights beyond that is a different question. If it was represented either through me or during the mediation, and it was material to the settlement, the one thing I would say is the way to do it is to drop that fact into the settlement agreement, which is where sometimes those whereas clauses, which bother us so much sometimes, but can come in handy.
I have had situations where I have had attorneys ask me to go in the other room and tell a fact that I know is not true. And I won't do it. I've told them, I said, you can go in the other room and tell them that, but I am not going to go tell them that. And then that typically shuts that down pretty quickly. To your point too, is I'm not sure I've ever seen a settlement agreement, at least one, you know, our forms are a lot alike because suspiciously we work together to put it together, but the some small differences, but it does not say the defendant didn't do anything wrong. It just says we're just not making a statement as to an admission that this is wrong, and for that specific reason.
You want to move on to failure to disclose? You think actual disclosure stuff? Let's get to slide 9 and talk about failure to disclose, and that is in representing a client, a lawyer generally doesn't have a duty to disclose, but under these ethical rules, to the extent that the lawyer is aware that the client is engaging in conduct that would be criminal, or a criminal act, or a fraud, then the lawyer has a duty to speak up, and this is frankly for some a little bit more difficult. We were talking about examples that we might be thinking about. We're thinking about the conveyance of a gas station where no representations as to environmental viability or toxicity or anything else are being made. Then the lawyer need not say anything, even if the lawyer knows that there may be an issue there. But if the client says the EPA gave me a clean bill of health, where the lawyer knows that that is not true, that would be a fraud. And under my reading of the rule, the lawyer would have a duty to speak up, also in the context of the commission of a crime.
Yeah, I was trying to. Well, let me ask you this question. So, from the standpoint, and I think one of the other examples we were talking about are, you see on these failure to disclose house cases where it has as is language, and it says, you're taking this house as is, and somebody doesn't represent something because there's that as is language. For example, that whether you had somebody come in and do work and didn't get a permit. There's a question in the standard contract about that. It asks, and they don't reveal that, or they don't put anything in there because they have that as is language. Do we think that's right?
The answer is I hope so, by the way.
Yeah. I think if the affirmative question is asked in there, the as-is language in that agreement doesn't give you a free rein to lie about something. You've got to actually to express it. Now, there may be things about the house that people may not find attractive, and I can't remember. There may be case law out there, and you guys may know about it better than I would. But I was just trying to think of an example of, let's say, because I don't think there's a specific question in those disclosures, but let's say, for example, that somebody died in the house. Do we have any obligation to say anything about that? I think you do. What?
No, I think that is a question.
Oh, is it a question?
I believe it is.
Okay.
Right.
It requires it. Let's assume that it didn't require it. Do you think you have an obligation to reveal it, even though it may be harmful, may affect the value of the house?
And one of the things to do is
immoral.
As I was reminded in law school, is, John, it doesn't always matter what you think. Let's go back to the rule, right? And that is, at the end of the day, would it be a crime or a fraud that is being perpetrated? And so, if there is a statute or some other authority that would make non-disclosure a fraud, then that would lead us one direction. Well, obviously, if the client is affirmatively representing that nobody died in the house, set aside any duty to disclose or not, then as the lawyer, you got to step up, assuming again that that's a material fact, because fraud, of course, requires a material fact. You got me always going back to materiality.
So,
I think we go on to number 10. That's you, John.
yeah. Well, some of this we've talked about with regard to guidance and the ABA opinion. I can't even read my own slide here. So we've talked about what you can and can't do in these mediations as far as posturing. A few more examples. What if you say in a mediation something along the lines of, this witness's testimony is going to kill your case? Is that unethical? I'm seeing some head shaking. Puffing. That's
assuming
right.
The witness is alive and going to testify.
But if the witness is dead.
Yeah. You did. Yeah.
Okay. The bottom lines. What if somebody says our bottom line is $1 million? That's okay?
Even if it's not. Again, at the beginning of the discussion, there was the exception for representation as to willingness to settle, or some words to that effect, and so you are good. You're good there.
What if this? I think I already gave the example about this. No, I actually didn't give this example. We talked about this earlier. This is the best case I've seen in 20 years.
All the eyes of the beholder.
Better ingredients, better pizza.
Better pizza. That's right. Anyone else have any examples? Quiet crowd. Yeah.
And the other side is what? So well, and I think the one is if it's couched as an opinion, then by definition it's not a material fact, right? And so and I very often see it couched in terms of you may want to think about the possibility of DTPA trebling, and the response is your client is IBM. I don't think they're a consumer, or or whatever else it may be. But in almost every case, we have folks that infill with damages that are certainly, we'll just say, less likely to be recoverable than others. And I think particularly early on, people think of that more as opinion than assertions of fact.
Follow up on hers. How about when you have a lawyer who says you have individual liability, but they know there's not. In other words, you're suing a company, and your directors are going to be individually liable, but they know law, or they know it's not true.
So at the beginning of the discussion, it was you're not allowed to make a material misrepresentation of fact or law, and so I think you may be in trouble there, or you wouldn't be, but that bad actor would be.
Although you see all the time lawsuits in which they sue the individual and they sue the company. Yeah. This all starts to make my head hurt. Let's say you had an example. We talked about damages. Let's say that the other side has made an error in their damages calculation, and their damages are actually $100,000 more than what they think they are. Do we have any obligation to say anything about that? Everybody's shaking their head like, heck no. I would agree with that. John, what do you think?
I would not disagree, but let's tease that out just a little bit, and that is, let's say that the plaintiff on the second turn, the plaintiff has given me 5 different categories of damages, and on the second turn we discuss with the plaintiff that there's no possibility of recovery of $1 million of the 5 categories of damages that were listed, and so the plaintiff drops his demand by $1 million on the second turn, and we go back. And I said, the good news, the plaintiff has dropped their demand by $1 million, which in terms of the percentage of recoverable damages that the plaintiff has reduced is 0, right? Because they're still demanding 100 cents on the dollar on things they could recover. Do I have an obligation to disclose that? Do I have to disclose how it is that we got to a lower demand, or do we just take the lower number in there and hope we build a little momentum? I'll say it one more time, and then if it's too convoluted, but the plaintiff has 5 different categories of damages, and in one category the plaintiff concedes on the second go round, I can't get treble damages, say, and so I'm going to reduce my demand by what the strip that would have been those treble damages, but otherwise my demand remains the same. Now there's a reduction in the demand. Do I have an obligation to tell the other side how it is we got to a lower number? Or do we just take the lower number in and hope for the best? Or the plaintiff just says, I'll drop my demand by the amount of bogus damages. But I'm not sure there's an answer to that.
I would think that if they haven't asked, defense didn't ask, then I wouldn't say anything. If they asked, then I would go back to the plaintiff.
I'll take that answer, and I like that one.
So Taylor, why don't we go to the next slide? So
Got it.
How do we stay on the right path, John?
Got it. Well, and by the way, Taylor, tell me if I'm wrong. I've got us having about another about another 7 minutes. Is that right, Taylor? Got it. So, by the way, had I said 9 or 5, she'd have gone with that too, probably. That's okay. So, this is the
ethical.
This is the part where we want to sort of call out the idea that just being compliant with the ethical standards may not be enough. I mean, can you imagine the federal judge that says, "Look, I need a special master in this important, ethically difficult case, and so I want that lawyer that is absolutely the best at technically complying with the ethical laws or the ethical rules." I think here there are ways that we can think about our conduct that may get us, again, appeal to our own morals and others, but where we can do a little bit better. And one of the examples that I pulled a long time ago was how many out of 5 dentists recommend Trident? You remember that old? It's actually not true. It is 4 out of 5 dentists recommend Trident for their patients who chew gum. But they say really loudly, 4 out of 5 dentists recommend Trident for their patients who chew gum. And so the question is, some things may be lawful, but may be awful. And so one of the things that, particularly when speaking with younger lawyers, that I like to do is talk about staying way away from the line and doing the best that we can there. But some of the things that we look at are reciprocity, and how would I want others to treat me in this situation? Would I want them to know about the orange salmon, or would I feel comfortable with this on the front page of the New York Times? Or what would my friends back home think? I often run that. That's a filter that my friends back in Hurley, Mississippi, I think, have a filter that is important to me.
Would I have a problem if anyone read this letter I just wrote or this email I just wrote if they saw it?
That's exactly right.
Yeah. What if my mom's there? What would my mom think about this?
Exactly. Taylor, you want to take us to number 12? That's John Shipp's slide.
This is mine. So, one of the things we need to, in the words of poet laureate Ice Cube, check yourself before you wreck yourself. We need to check our behavior and we need to check ourselves. Some of the things, I mean, here's the thing: moral relativism. I'm not suggesting that we go with that, but the idea that moral judgments are true or false only relative to some particular standpoint, and no particular standpoint is more privileged than the other. That's not. In other words, that's another way of saying that if you try hard enough, you can justify anything to yourself. So, some examples of some things. If you find yourself asking or saying these kind of things, check yourself here. The other side is bad, so it's okay to bend the truth. They're bad people. The ends justify the means. My purpose is just, so it's okay to do this. Everybody does it. Everybody speeds, whatever it is. It's for a good cause. Those are another ones. If it isn't illegal, it's not unethical. The big one is, the biggest, the example that I can think, slavery was once legal. That's obviously unethical. And just because there's a law out there doesn't necessarily mean that it's not unethical. If I don't do it, someone else will. I see that a lot. They're doing it to me, which is he hit me first, with mom and dad, and just this one time, which always seems to lead to another time. So those are all things that we need to be careful about. And so also, you think about things. Am I getting too cute here? How's the other side going to perceive this? Are they going to take it the wrong way? These are all things that we need to be thinking about from the standpoint of trying to be ethical and moral in our negotiations.
If we can go to 13, and I want to just sort of make one quick statement here before we go to slide 14 in a minute, but not now because 14 has the best picture on the internet. But 13, see that drum roll, please. But 13, I will say, play the long game. We won't overemphasize this too much, but what I will say is my view on some of this and the importance of some of these issues has changed a bit over the past few years. I sit as an arbitrator now almost half the time, and I've had people who have been caught, lawyers who have been caught in material lies in my proceedings, and the unfortunate thing is it taints everything they say. It is almost impossible as they speak or as they write not to be double checking every single time they speak. And so I know it's cliche to say don't lie, but the impact may last a lifetime. Let's go to that best photo on the internet, John, number 14. Oh, there it is.
Yeah, the question is it unethical for me to represent that I look like that? That's an 8-year-old picture. I do need new pictures, but yeah, the advice I gave, and I will tell you that it may be unethical and maybe immoral for me to represent that this is my quote, but at the time I wrote it, I thought it was. I'm not smart enough to keep track of the lies and manipulation. It's just easier to tell the truth, and so that once I kind of thought through that, it just made life so much easier that you don't have to worry about what you say and what you don't say. A couple years ago, I ran across someone that said almost the exact same thing, and my first thought was, that SOB Mark Twain stole my idea. And then realized that was impossible. But I was a huge Mark Twain fan growing up. I obviously subconsciously picked up on that and so forth, and it's not lost on me that I've lied to you and showed you, misrepresented my picture as ending this speech. But I do think that that's a great rule of thumb, is if you're always telling the truth, you don't have to worry about things. So, and I think that's, unless anyone has any questions, that's our presentation. We really appreciate it.
Thank y'all. Appreciate it. Thank you.